Hey everyone, Mike DeBliss here. Welcome back to the webinar on Demystifying the FBAR. We're now on Module 4, Willfulness. Let's begin with a primer on willfulness. One small word is all that distinguishes a civil tax matter from a criminal tax matter. That word is willfulness. It's the cornerstone of any criminal tax matter. Now, the most common crime that the government charges in connection with a willful failure to report an offshore account is not what most people would think. It's not always tax evasion. Instead, it's the crime of willful failure to file an FBAR. The willful failure to file an FBAR is a felony that's punishable by a prison term of up to 10 years and criminal penalties of up to $500,000. Willfulness is a necessary element not only of tax crimes, but also of willful FBAR penalties. Now, in the criminal setting, the government carries the heavy burden of proving, beyond a reasonable doubt, of course, that the taxpayer acted willfully. How is willfulness defined? Well, the textbook definition of willfulness is an intentional violation of a known legal duty. Now, while those 7 words might sound very easy to understand, they are loaded with meaning. Each word has a very specific definition that courts have interpreted. So how do courts interpret willfulness? They interpret it like this. The only thing that a person need know is that he has a reporting requirement. And if a person has that requisite knowledge, the only intent needed to constitute a willful violation of the requirement is a conscious choice not to file the FBAR. That last phrase, a conscious choice not to file the FBAR, is referred to in legal circles as the theory of willful blindness. What does it mean for a defendant to be willfully blind? Well, under the theory of willful blindness, a jury may infer willfulness whenever a taxpayer intentionally fails to inquire and learn about his or her filing obligations. What this means is that instead of the government having to prove that the defendant intentionally violated a known legal duty, the government need only show that the defendant consciously avoided any opportunity to learn what the tax consequences were. An example that I like to use here is that it's the equivalent of an ostrich sticking its head in the sand. That is a real world example of what it means for a defendant to consciously avoid learning what the tax consequences were. Literally burying his or her head in the sand so that he or she can be ignorant, wholly ignorant of the reporting obligations. How does the government prove willfulness in the prosecution of a taxpayer for failing to file an FBAR? Well, as you can imagine, there aren't witnesses, or seldomly are there witnesses, and only in a rare case would a person admit the required state of mind. It unfortunately does happen, however, and sometimes these statements or confessions come during very weak moments before the taxpayer has retained private counsel. But seldomly so. It's still very seldom that a defendant would admit the required state of mind, meaning that he or she intentionally violated a known legal duty to file an FBAR. So what does the government rely on? Indirect evidence, specifically conduct or acts from which a person's state of mind can be inferred. Now, isn't that interesting? Conduct or acts from which a person's state of mind can be inferred. At a very primitive level here, the IRS and the Department of Justice can't open up a person's head to see what they were thinking back when, back when there was an FBAR reporting obligation and the taxpayer didn't file the FBAR. So this is what substitutes. The government looks to any conduct or acts from which the taxpayer, who's now a defendant in a case, mind can be inferred. These acts are commonly referred to as badges of fraud. Now we're going to go through the list of badges of fraud, and interestingly enough, as we go through this list, what I want you to be very cognizant of is that a lot of the badges of fraud that are listed here can very simply be benign conduct by themselves. So my point here is that not every single badge of fraud in isolation can be used to prove willfulness. And in many cases, the taxpayer will have an entirely neutral spin on the specific fact that is otherwise listed under this topic of badges of fraud. So be very mindful of that. It's not any single one of these that is the be-all and end-all that will help the government create an airtight case for willfulness. It's more or less a combination of these that leads to a strong case of willfulness. So I'm going to go through the laundry list right now, and I want you to keep that in mind as I list these badges of fraud, because many taxpayers will have one or more of these in common. And again, they have as much a neutral or benign spin to them as they have what the government would attribute a nefarious or deceptive motive to them. So here we are. Examples of some common badges of fraud that are sure to attract the IRS's attention. First, a taxpayer who checks the box off no on Schedule B in response to the question, do you have an interest in or signature authority over a financial account in a foreign country, when in fact he has just such an account. As many of you are familiar, this comes from number 3 on the 1040. Again, it's Schedule B, and it asks the question point blank, do you have an interest in or signature authority over a financial account in a foreign country? There are 2 boxes, one for yes and one for no. The taxpayer who checks the box off no on Schedule B, when in fact he has a foreign account, is going to have some explaining to do. Because a foreign account is a foreign account is a foreign account. This isn't asking anything specific about whether you had a duty or an obligation to file an FBAR. That of course requires a little bit more knowledge of the FBAR reporting requirements because of the thresholds and whether an account even triggers an FBAR filing obligation. This is just asking the plain, straightforward, vanilla question, do you have a foreign bank account? Second, whether the failure to report the account occurred continuously over a period of years or whether it was merely an isolated incident. In other words, did the taxpayer's failure to file an FBAR occur over the course of time, meaning several years, or just 1 year? Obviously, a failure to report the account over a period of years is going to be harder to explain than merely an isolated incident where in 1 year the taxpayer may have inadvertently checked the box off no. So the pattern of several years where the box is checked off no when the taxpayer did in fact have a foreign bank account is going to require a lot of explaining. Third, whether the taxpayer failed to report a foreign account in a later year despite having checked the box off yes on Schedule B of his tax return in an earlier year, or perhaps filing an FBAR in an earlier year in addition to checking the box off on Schedule B of his return in that earlier year. This reveals that the taxpayer knew that he had an FBAR reporting obligation in the later year. So just so that you don't get confused by this example, let's consider a taxpayer by the name of John. And let's say that in tax year 2010, which is our later year, he had a foreign bank account. But John checked the box off no in 2010. Meanwhile, he had a foreign bank account in 2008 and 2009. And in both 2008 and 2009, he checked the box off yes that he had a foreign bank account and even went so far as to file an accompanying FBAR. So if he still had that foreign bank account in 2010, why did he check the box off no? Well, I can tell you right off the bat that the IRS is going to want to examine what the high watermark balance of the account was in 2008 and 2009 versus what it was in 2010. I can tell you unequivocally that if John's bank account rose significantly from, say, 2008 and 2009 to 2010, then the IRS is going to be very suspicious and likely infer a sinister motive on the part of John for checking the box off no in 2010. And again, their spin on what could otherwise have just been a complete oversight on John's part is that John was trying to get over on having to report a foreign bank account in a year where the high account balance rose dramatically from the last year that he had filed the FBAR, which was in 2009. Let's move on to number 4, the high watermark balance of the account. The amount of money at stake is crucial. If I said this once, I said it a million times. Now, why is the amount of money at stake crucial? Well, FBAR penalties are tied to the high watermark balance of the account, not the interest that's generated by that account and not the tax liability that results from that interest after taking into consideration foreign tax credits. So that is why the IRS places such scrutiny on the high watermark balance of the account. And that's why even if you have an account that is in the 7 figures, but at the end of the day has such little tax liability because the taxes were paid to the foreign jurisdiction and the foreign tax credit virtually offset or made the taxpayer's U.S. tax liability on that interest income negligible, that is completely irrelevant for this analysis. That's because, again, the high watermark balance of the account is what drives the FBAR penalty. Unreported accounts with maximum aggregate balances that are $500,000 or greater are heavily scrutinized. You can go to any tax attorney and you will be given this very same information. Those accounts that are $500,000 or greater are heavily scrutinized. As one prominent tax attorney is quoted as saying, if a person has a $10 million account, I don't want to hear he was non-willful, and neither does the government. Whether the taxpayer told his tax preparer about the account, that is significant. Don't think for a second that your tax preparer hasn't prepared a questionnaire or doesn't have notes handy about inventory or information that he gathered from you up front. And these days, very few, if any, tax preparers don't ask this pivotal question: do you have an interest in a foreign bank account? Next, whether the account was held in such a way as to conceal ownership. What do I mean here by conceal ownership? Well, was the account in the name of a foreign shell corporation or foreign trust or some other entity that would make it difficult for the IRS to learn the true identity of the owner? Was the account a numbered account? Was the taxpayer issued a credit or debit card without his or her name visible on the card itself? Now, these are just some examples of what I mean by concealing ownership. Now, you may very well have a foreign account that's that you own indirectly through a foreign corporation. Does that mean that you're going to jail? Absolutely not. Absolutely not. The IRS recognizes, and it is completely legal to have an ownership interest in a foreign shell corporate or a foreign corporation that in turn owns a number of foreign bank accounts. Most people living overseas are entrepreneurs who have started companies overseas, and it's not unusual for them to form a foreign entity. And when a foreign entity is formed, just as it is formed domestically, it has ownership of foreign bank accounts. So again, keep all of this in its proper context. A lot of these facts, or a lot of these factors rather, have just as much a benign spin to them as they could potentially have a sinister spin to them. As you can imagine, the more of these that the IRS can marshal in their favor, the stronger the case they can build against the taxpayer for willfulness. Next, did the bank help the taxpayer repatriate cash to the U.S. using covert means? And what I mean by that is this. Here are two examples. Did bank managers and their U.S. clients use code words in emails to gain access to funds? That comes out of a recent case. Second, did U.S. clients ever use coded language, such as asking their private bankers, quote, can you download some tunes for us, end quote, or note that their gas tank was running empty when they required additional cash to be loaded to their cards? How about this? Whether the taxpayer closed the foreign account and transferred the assets to another bank in the wake of a DOJ press release or media coverage reporting that the taxpayer's bank had become the target of an IRS summons. That one comes up not as frequently as others, but when it does, it is quite damaging. Because as many are aware, this type of information usually gets splashed across the front pages of major newspapers such as the New York Times or the Wall Street Journal. And if the timing of the closing of a foreign account that has become the target of an IRS summons is peculiarly close in time to the closing of that foreign account, then the IRS is going to look at that and say, geez, I wonder what was going on here. It seems as though this was a bit underhanded, that the taxpayer, on the heels of learning about the IRS summons that was issued to his bank, had closed the account and transferred the money to another account. That isn't going to pass the litmus test. There could be a logical explanation for it, but the spin that the IRS is going to put on it is that the taxpayer was clearly trying to continue concealing the accounts and deceiving the IRS. And in another case, it may not necessarily be an IRS summons demanding U.S. account holder information. It might be a press release where the bank agrees to participate in FATCA. Again, the example that I give is a headline splashed across the front page of a major newspaper. The next potential badge of fraud: whether a taxpayer who has a duty to file an FBAR checks the box off yes to the first question, that being, do you have an interest in or signature authority over a financial account in a foreign country, but no to the follow-up question. If yes, are you required to file an FBAR to report that financial interest or signature authority? Now, the last question, if yes, are you required to file Form 90-22.1, otherwise known as an FBAR, to report that financial interest or signature authority? That very question gets to the heart of the matter. Must an FBAR be filed? So just because the taxpayer may have rightfully checked the box off to the initial question by checking it off yes, doesn't mean that they're out of the woods if they've checked the box off no to the follow-up question. At the end of the day, if that foreign account meets the definition of a foreign bank account for purposes of FBAR reporting obligations, and the taxpayer checked the box off no, there's a potential problem there. The taxpayer is going to have a lot of explaining to do. Now, of course, there are times when the box could be checked off yes to the first part and no to the second part. What might be an example of that? Well, if the high watermark balance of the account did not exceed the threshold for FBAR reporting obligations. What is the threshold for an FBAR reporting obligation? It's $10,000 US, meaning the high watermark balance of the account has to be 10,000 or greater in that year. In some cases, a taxpayer who has a single account and whose high watermark balance is only $9,999 can rightfully check the box off yes to the first question and no to the follow-up question. Next badge of fraud: the amount of interest, and I'll say this over and over and over again, the amount of interest generated by the foreign account and whether that interest, no matter how negligible, was reported on the taxpayer's U.S. tax return. Let's get something straight right from the beginning. It does not matter how negligible the interest income generated by the foreign account was in a given year. The IRS's company line specifically states that. So even if the foreign account generated just $1 of interest income in the tax year, it doesn't matter. If the high watermark balance of that account exceeded $10,000, then in the IRS's mind, it should have been reported on an FBAR. And the IRS doesn't care how minor the interest was. Again, that's because because FBAR penalties are tied to the high watermark balance of the account and not the interest income generated by the account. In other situations, taxpayers will say, that will acknowledge readily that the account generated a significant amount of interest, but that they paid taxes on that interest to the foreign jurisdiction. And that after taking into consideration the foreign tax credit, their U.S. tax liability on on the interest generated by their foreign account is negligible. Just like in the case of where the interest generated by the account is negligible, it's still not as big a factor as the taxpayer might think. That still doesn't excuse the taxpayer from having to report the account on an FBAR. However, what's interesting here is the following. Let's say, for example, that the taxpayer does everything he should have done as far as reporting the interest generated by his foreign account to the foreign jurisdiction and paying taxes on that. And let's say that the taxpayer takes the added step of actually reporting the interest generated by his foreign account on a 1040 and paying whatever tax is necessary on that. At the end of the day, in terms of compliance, the IRS has stated very specifically that in a scenario like that one, the filing of an FBAR is merely a formality, and that the taxpayer need only file delinquent FBARs and submit the delinquent FBARs. Why? Because at the end of the day, he or she properly reported the interest income generated by his or her foreign account on the 1040 and paid whatever U.S. taxes that he or she owed on that interest. So the fact that an FBAR wasn't filed is a mere formality. So that's the one exception that a taxpayer can hang his hat on. Next, whether the taxpayer instructed bank personnel to hold back his bank statements and not mail them to him in the United States. And in parentheses here, if the U.S. residence was listed as the account holder's primary residence. The next badge of fraud, whether the taxpayer had been subject to a previous audit involving unreported offshore assets or bank accounts. Finally, the number of foreign accounts held. And again, I preface all of this with the following. Just because a taxpayer may have 10, 11, 12 foreign accounts doesn't mean that he or she is the Al Capone of the offshore tax evasion world. There are legitimate reasons why a taxpayer may have numerous foreign accounts. There are legitimate reasons why a taxpayer may have set up a foreign entity that in turn owns foreign accounts and that the taxpayer may have signature authority over. So don't look at any one of these in isolation and say to yourself, oh my God, the IRS is going to be able to prove willfulness. It's more or less a combination of several of these with with a sinister, coupled with a sinister motive. And it's one of those things where you can see it and you can smell it from a mile away. It's almost like the Supreme Court in the one case that they were deciding several years ago involving pornography. One of the justices said, I can't, and this was in describing pornography, he said, I can't describe it, but I know it when I see it. And that is essentially the litmus test for better or for worse when it comes to willfulness. Of course, if you want something a little bit more substantial and concrete to hang your hat on, generally speaking, the more badges of fraud that exist and um, uh, the more these badges of fraud are, um, the more these badges of fraud are are exacerbated, meaning the more they really jump out at you in terms of the impunity with which the taxpayer engaged in that conduct, the more likely it is that the IRS will be able to prove willfulness. No single factor is dispositive. It is a totality of the circumstances test. So let's turn now to willfulness for purposes of civil penalties. Remember what we talked about earlier. There is willfulness for criminal penalties as a necessary requirement, and then there is willfulness for civil penalties as a necessary requirement. So willfulness is an essential element of a willful civil FBAR penalties. In other words, to the extent that the examiner attempts to assert a willful FBAR penalty, it must be supported by evidence of willfulness. Not surprisingly, willfulness is the battleground whenever the IRS attempts to assert a willful FBAR civil penalty. And what I find taxpayers getting confused with on this front is the following, and I understand what the cause of confusion is. When it comes to the IRS asserting willful FBAR penalties, I want to be very clear. The burden is on the IRS to prove willfulness. It's not on the taxpayer to prove non-willfulness. I want you to stop and think about that for a second. This issue has become very confusing to taxpayers in light of the recent expansion of the streamlined procedures. When a taxpayer decides to come into compliance using one or more of the streamlined procedures, there is something referred to as the non-willful certification, where the taxpayer is expected to describe in detail why his or her failure to report his bank accounts was non-willful. Now, distinguish that from a situation where the taxpayer decides not to come into compliance through the streamlined procedures, but merely decides to file delinquent FBARs or amend FBARs that have previously been filed, perhaps going back 6 years or more. Let's say that under those circumstances, the IRS asserts an onerous willful FBAR penalty. In that case, the taxpayer will not be expected to complete a non-willful certification. Instead, if the IRS asserts the willful FBAR civil penalty, it's their burden of proving willfulness. And that dovetails into the fourth bullet point here. While the burden of establishing willfulness for purposes of asserting an FBAR civil penalty is on the IRS, the standard of proof is less than what it is for willfulness in the criminal context. So remember we talked a little while ago about how the standard of proof for proving willfulness in the criminal context is beyond a reasonable doubt. That goes without saying. Whenever a taxpayer is indicted, meaning charged criminally with a tax offense, it's the burden of the government to prove each and every element of the offense beyond a reasonable doubt. That goes back to time immemorial. In a criminal setting where a person risks losing his or her liberty, the burden of proof, or the standard of proof rather, on every element of the crime is beyond a reasonable doubt. But now, because we're in the civil arena, where we're dealing with the IRS asserting a willful FBAR civil penalty, the standard of proof is less. Instead of beyond a reasonable doubt, the IRS need only establish willfulness by clear and convincing evidence. Interestingly enough, the definitions of willfulness are the same whether we're in the criminal arena or the civil arena. The IRS has adopted the same definition of willfulness, an intentional violation of a known legal duty. Now we're going to get into something very interesting here. We've talked about the burden of proof. Now we're going to move on to, practically speaking, how easy or difficult is it for the IRS to prove willfulness for purposes of asserting a willful FBAR penalty? This is what I call lowering the bar for willfulness for FBAR penalties. We're going to touch briefly on the case of Williams. Many of you have already heard of the case. It's now a couple of years old, and it spread like wildfire after the decision was announced. It was a decision from the Fourth Circuit Court of Appeals, and it dealt directly with the issue of willfulness for asserting FBAR penalties. In that case, the Fourth Circuit Court of Appeals diluted the quantum or amount of evidence that's needed to prove willfulness for purposes of asserting a willful FBAR civil penalty. For this reason, J. Brian Williams, who was the taxpayer in the case, is a name that U.S. persons with unreported foreign bank accounts have come to dread. So let me give you a quick overview of what was going on here. We're going to back up a little bit and just cover some basics. Every 1040 contains what's called a jurat, just above the signature line. The jurat states the following, quote, "Under penalties of perjury, I declare that I have examined this return and accompanying schedules and statements, and to the best of my knowledge and belief, they are true, correct, and complete." What does this mean? Let's break it down. Very simply, there is a presumption in the law that a taxpayer who signed his 1040 did in fact examine the return, and that it is true, correct, and complete, even if the taxpayer did not actually review it. Ouch! So again, this is a fiction that the law indulges in. For better or for worse, there is a presumption that the taxpayer who signed his 1040 did in fact examine the return, and that it is true, correct, and complete, even if he really didn't. Now, the Fourth Circuit Court of Appeals reasoned that Mr. Williams made a conscious effort to avoid learning about the reporting requirements. Now, if that phrase, conscious effort to avoid learning about reporting requirements, sounds familiar to you, it should. It tracks the language of the very definition of willfulness, intentional violation of a known legal duty. Now, while the majority, as you can, and by the way, just to back up for a second, you can, you don't have to be a weatherman here to see which direction the wind is blowing in. Obviously, the Fourth Circuit Court of Appeals has taken the position of the government here by virtue of finding that good old Mr. Williams made a conscious effort to avoid learning about the reporting requirements. While the majority could have rested there and concluded that the record established willful blindness by clear and convincing evidence and reversed on that basis alone, they decided to go one step further. And that one step, my friends, created a firestorm of opposition. It basically opened up the floodgates for critics to come out and heavily criticize the opinion. So what did the majority hold that created this much opposition? The majority held that Williams's signature on his tax return was, quote, prima facie evidence that he knew the contents of the return, even though Williams testified that he never reviewed it. So Mr. Williams, during his civil trial, took the stand and swore under penalty of perjury that he never reviewed the return. Notwithstanding, the majority held that his signature on the return was prima facie evidence that he knew its contents. Here's the court's analysis. Because Mr. Williams was presumed to have known the contents of the return by virtue of having signed the 1040, the court reasoned that he was cognizant of the FBAR filing requirements. Why? Well, recall that Section 3 of Schedule B specifically refers the taxpayer to the FBAR and its accompanying instructions, which contain the FBAR filing requirements. So let's stop for a second and just let this sink in. How do we get from point A here to point Z? Once again, there's a fiction under the law that a taxpayer who signs their 1040 right above the jurat, in signing the 1040, he or she is presumed to know the contents of the return, and he or she is presumed to have sworn or certified that everything is true, accurate, and complete. So because Mr. Williams was presumed to have known the contents of the return by having signed it, the court reasoned that he naturally was cognizant of the FBAR filing requirements. Well, how can that be so? Because Section 3 of Schedule B specifically refers the taxpayer to an FBAR, meaning it specifically refers the taxpayer to an FBAR and tells him or her to review the requirements for filing an FBAR. So if the taxpayer was presumed to know the contents of the 1040, and the 1040 included a reference to the FBAR and its accompanying instructions, then Mr. Williams must have been cognizant of the instructions that were contained on the FBAR. And this is where things go south real fast for Mr. Williams. Once again, the question that I'm referring to on Section 3 of Schedule B that refers the taxpayer to the FBAR is this question. And just so there's no confusion in your mind, when the question refers to Form TDF 90-22.1, all that is the form number for an FBAR, so that there's no confusion. Again, the question asks, if yes, are you required to file an FBAR to report that financial interest or signature authority? See Form 90-22.1
and its instructions for filing requirements and exceptions to those requirements. So the question doesn't stop there. It specifically directs the taxpayer to read the instructions for filing and exceptions to those instructions on an accompanying FBAR. And as I said, that's how knowledge of the FBAR reporting requirements was imputed to good old Mr. Williams. And as you can see here in the last point, I emphasize this once more. Schedule B's reference to 114, FinCEN Form 114 or FBAR, and its accompanying instructions were deemed to have put Williams on inquiry notice of his FBAR filing requirements, even though he never reviewed the 1040, much less the filing instructions on the FBAR. So at the most primitive level here, we see how unfair these presumptions are to somebody who hasn't even read his 1040, let alone knew that the 1040 had referred him to an accompanying FBAR to read those instructions. Yet, because of these presumptions under the law, the court was able to take this gigantic leap and impute knowledge of FBAR reporting requirements directly to Mr. Williams. What does this case mean for the average taxpayer with an unreported foreign bank account? Well, such taxpayers are presumed to be cognizant of the FBAR filing requirements merely by signing the tax return, assuming, of course, that the return contains a Schedule B, a Section 3 Schedule B. Okay, and here I want to make a very clear distinction. The signature that imputes knowledge of the FBAR reporting requirements is not a signature that is placed on the FBAR itself, but it's a signature that is placed on the 1040. So long as a 1040 has a Section 3 Schedule B and the taxpayer signed that 1040, knowledge of the FBAR reporting requirements have been imputed to the taxpayer, and he is expected to have a working knowledge of all of the reporting requirements. So if the taxpayer proceeds to check the box off no to the question, did you have an obligation to file an FBAR, that is a potential badge of fraud, because the IRS assumes that the taxpayer checked the box off no, even though he had knowledge of the FBAR reporting requirements. The practical effect of this opinion is nothing short of mind-blowing. Instead of having to prove a specific intent to violate a known legal duty, remember that definition that the IRS had given us, or that case law had given us earlier for willfulness, intentional violation of a known legal duty? Well, that's gone out with the bathwater now. So instead of the government having to prove a specific intent to violate a known legal duty, which virtually every other tax case has upheld as a standard for proving willfulness, the case of Williams makes a taxpayer liable for willful FBAR penalties based on nothing more than his presumed understanding of the FBAR requirement. As some tax professionals like to put it, at one extreme, Williams has given the IRS carte blanche to assert a willful FBAR penalty for something as arbitrary as a dislike for the color of a taxpayer's shoes. The Empire Strikes Back. What the heck am I referring to here? Keep in mind, as we've discussed earlier, that just because the IRS thinks that a willful FBAR penalty is warranted does not make it official. For example, a taxpayer can challenge the assertion. In doing so, he'd be putting the IRS's feet to the fire by holding them up to their burden of proving willfulness in court. By the way, it's important to note here that while few taxpayers will actually hold the IRS's feet to the fire and take them to court and force them to prove willfulness, those that do sometimes come out with a far different result than what the IRS determined. And the reason being is, as we said, the IRS has to prove willfulness in court, and the taxpayer can demand a jury trial in which the issue of willfulness is litigated. So for all intents and purposes, it would then be up to a jury as a trier of fact to determine whether the government has proven willfulness by clear and convincing evidence in a trial. It would, of course, be a civil trial because we're talking about willfulness in the context of the willful FBAR penalty. Needless to say, attacking the assertion of willfulness can become an expensive proposition because you're at that point retaining an attorney, a tax attorney who is going to obtain the best possible result. And if the case doesn't resolve short of trial, the trial, of course, could go on for several weeks, and litigation can become costly. As illustrated in the Zwerner case, the IRS must prove willfulness to the satisfaction of a jury. And while willfulness need only be proven by clear and convincing evidence in the civil context, the fact remains that proving the existence of a mental state is easier said than done. Remember what we talked about. At the most primitive level, the IRS can't open up a taxpayer's head and pull out the thoughts that they were thinking right around the time that they failed to report their foreign account. This is not a Harry Potter movie where Dumbledore puts a magic wand over another wizard's head and sucks out their memory and puts it into a memory glass or some type of magical instrument and replays all of the memories from that time. Would it be so? I'm sure that the IRS would be all over that in a heartbeat. Instead, in order to make out a colorful claim of willfulness, the IRS has to rely upon facts and circumstances, meaning indirect evidence that can give them an idea of what the taxpayer was thinking back then. So definitely a person's acts and conducts can demonstrate their state of mind and what they were thinking back at the time. Now, even if the IRS can make out a colorful claim of willfulness at trial, the taxpayer can mount a vigorous defense. These defenses are usually grounded in reasonable cause. So, here's the takeaway. While Williams gave a major boost to the IRS's efforts to root out or stamp out offshore tax evasion by making it easier for the government to prove willfulness, taxpayers can take comfort in the following. First, Williams is an unpublished opinion. Why is that significant? Well, because it's an unpublished opinion, it's not binding precedent on federal courts in the Fourth Circuit, much less any of its sister circuits. Second, if the Internal Revenue Manual is any indication, it appears that the official position of the IRS is to require a higher, yes, a higher quantum of proof to establish willfulness than what the court in Williams required. Believe it or not, the IRS has actually acknowledged that a higher quantum of proof than, or actually has endorsed a higher quantum of proof than for willfulness than what the court in Williams required. So, in other words, the IRS will not indulge in the fiction that a taxpayer knows and understands his FBAR reporting requirements merely by having signed his return. So what is the standard that the IRS uses? We talked about it up at the top of the webinar. According to the Internal Revenue Manual, the IRS uses the following standard when determining whether willfulness exists in a civil context. First, the taxpayer must know that he has a reporting requirement. And second, to the extent that the taxpayer has this requisite knowledge, the only intent needed to constitute a willful violation of the requirement is a conscious choice not to file the FBAR. Again, in legal circles, this is referred to as willful blindness. It's analogous to the hypothetical that I gave you earlier about an ostrich that digs its head into the sand. Fully knowledgeable of the fact that there are some FBAR reporting requirements out there, but puts his head into the sand to avoid learning about those requirements. So it doesn't necessarily mean that the taxpayer actually knows specifically what the requirements are, but instead that the taxpayer knows that they're out there and that they may apply to him, but makes no effort to learn about them to satisfy his reporting requirements. The following examples illustrate situations in which willfulness may exist for purposes of asserting the civil FBAR penalty. These come directly from the IRS's internal revenue, or directly from some hypotheticals that the IRS has posted on their website. And this is in the civil context, once again. So we have Jill. Jill has a foreign bank account. She admits knowledge of, but fails to answer the question on Schedule B of her return concerning whether she has an interest in a foreign account. When asked, Jill doesn't have a reasonable explanation for failing to answer the question and for failing to file the FBAR. A determination that the violation was willful would be appropriate. Again, this is not my example. This comes from the IRS. But I want you to see, by studying the hypotheticals that the IRS has provided, that will give you guidance on how the IRS is likely to view your submission or your filing of delinquent FBARs. In example 2, we have Jack. Jack has a foreign bank account that he has failed to report. He received a warning letter informing him of the FBAR filing requirement. Notwithstanding that, he continues to fail to file an FBAR in subsequent years. When asked, Jack does not have a reasonable explanation for failing to file the FBAR. To make matters worse, Jack failed to report income associated with the foreign account. Remember how we talked about earlier that if a taxpayer has reported the interest income on the foreign account to the foreign jurisdiction, pay taxes on it, and if he took the added step of actually reporting the interest income from that account on a 1040, but merely forgot to file an FBAR, the IRS would take the view under those circumstances that the failure to file an FBAR was trivial and insignificant, and in those cases recommends that the taxpayer merely file a delinquent FBAR and disclose the bank account. So at the end of the day, the IRS's position is no harm, no foul. But in this case, Jack failed to report the income associated with the foreign account. And as you can see here, the IRS company line is that a determination that the violation was willful would be appropriate. This takes us to the end of the module on willfulness. As always, I welcome your questions. Please feel free to contact me at the telephone number that you see on the screen, or at my email address, or feel free to visit my website at theblisslaw.com. It's just been totally redone with a fresh new look, so I encourage you to take a look at it. I also need to make this disclaimer. The information that was discussed in this webinar is very general information. By no means has it been customized to your individual facts and circumstances. So with that in mind, you cannot rely on the information that's in this webinar for purposes of helping you with your individual matter. And it's always recommended that you contact or talk to a tax attorney. So look forward to seeing you in the next module.